Part of our commitment to putting Southeast Texas first means getting answers to your legal questions. Here on Wednesday afternoons, we ask the judge. Judge Courtney Arkeen is with us from the 128th District Court in Orange County. Judge, good to see you.
Good to see you too. Thanks for having me, Jordan.
Appreciate you making time. This first question comes from a viewer named Titiana. She says, I've heard both yes and no on this issue, so please help me gain clarity on my situation. She says, my mother passed away and left no will. She had a son who is my half-brother that was born in California. My half-brother was adopted by our maternal grandparents in Texas at the age of 17. My mother went on with her life and married my father. They shared a homestead together. My half-brother has inherited from our grandparents. I did not. Can my half-brother inherit from our mother even though he was adopted? And where does this leave me?
Okay, so a lot to unpack here. The first thing I would tell her to do is she needs to get a copy, if she can, of that adoption paperwork. Now, a lot of times it's going to be sealed, but the reason why she's getting conflicting answers is because if there was a termination of the parental rights that then went into an adoption, then he will not inherit, okay? But if there was not a termination and he was adopted by the maternal grandparents, then there could potentially be the ability to inherit, okay? So 99% chance there was a termination and a subsequent adoption and he cannot inherit. But that's where the question is becoming confusing. Was there a termination of those parental rights?
Sounds like a lawyer may be a help in this situation. I mean, this is going to get a little complicated, like you say. This second question is from a viewer named Myrtle, who wrote into 12 News saying, my neighbor across the street has a 75 to 80 feet pine tree that was struck October the 28th of last year by lightning. Now the tree is dying. I have sent her many letters and talked to her in person. That tree is a danger to our home and my husband's classic truck and car. She says she's selling her house and not cutting the tree. She still owns the house. I know it's her responsibility to have it taken down. Do I need a lawyer to make her cut it before it comes into our home and autos?
Well, a lot of times the answer that I'm giving ends with you need to contact an attorney to assist you. But in this question, I can tell her no, she does not need to contact a lawyer. You cannot make her cut down that tree. Now, she has sent plenty of notice to put the lady on notice that if it does fall and cause damage, that's going to help in her case of negligence, okay? But you can't force her. Now, if she does sell the property, then you need to go through the same steps and notify the new owner of the impeding tree, that it could fall, and you're putting them on notice that you will hold them responsible if they do not cut the tree and damage is done to your home or classic truck.
And how would you eventually hold them responsible? In civil court?
Yes, you would need to file a civil case.
All right, there you go. Judge, it's good to see you. Two interesting questions this afternoon. Hope we helped out our viewers.
I hope we did too. They were different, and so that's good to teach some of the viewers a different subject matter. I enjoyed it. Thank you.
We appreciate you doing the research. And folks, if you've got a question, we've made it really easy for you to connect with us. Go to 12newsnow.com/askthejudge. There's a form to fill out right there, and hopefully we'll get to your question next week at 5.